So it's topic 5. It's topic 5. Share capital. Share capital. So today you can take maybe some short notes. So I won't be dictating anything. So here I'll just be explaining. So because I've already shared the notes, so I'll just be explaining. So if you can take some short notes, you can be able to take them because the notes I'm going to discuss, you already have them. The notes I'm going to discuss, you already have them. So don't start asking to tell me that, wait, Malim, I'm writing. So that won't be my problem. I wait, you are writing, me, I'll just be discussing. As I write a few things here on the board, you can write yourself, or you can be having the notes I've already shared. Because what I'm going to discuss is just basically what is actually already in the notes, is what in this case already is actually in the notes, and majorly it is actually the super highlighted areas. So under the topic of share capital, this is what you're going to in this case look at under the topic of share capital. So we're going to understand what is share capital. So what is exactly share capital? What is share capital? What is share capital? What is share capital? Then we look at, in this case, share premium. We're going to look at share premium. This is what we've already been able to mention it previously, but we'll also be able to look at it. The types of share capital we can be able to have in a company, types of share capital, the types of share capital. The types of share capital you can then actually be able to have in a company. We're going to look at something we refer to as a prospectus. There's something we call a prospectus. As prospectus, under the prospectus, you'll see what are the contents of a prospectus. What are the contents of a prospectus? What are the contents of, in this case, what a prospectus? Also, we look at something we refer to as a misleading prospectus. Under the effects of a misleading what prospectus? A misleading prospectus. We look at, in this case, a misleading prospectus. And in this case, what are the effects of, in this case, what we refer to as what as a misleading prospectus? There was something in this case we refer to as a statement in lieu of a prospectus. A statement in lieu of a prospectus. There's something we refer to as a statement in lieu of a prospectus. So what do you mean by a statement in lieu of a prospectus? Then we'll be able to look at, in this case, the methods of issuing shares, or we can also say the methods of raising capital in a company. The methods of raising share capital in a company. The methods of raising share capital in a company. Then we'll, in this case, predominantly also in this case, look at what we refer to as a reduction of the share capital. Reduction of the share capital. We're going to look at a reduction of the share capital. A reduction of the share capital. We look at a reduction of the share capital. Then there's something in this case we refer to as maintenance of the share capital. Maintenance of the share capital. Maintenance of the share capital. We look at maintenance of the share capital. Then here, there's also a very famous case law in company law. There's another very famous case law in company law. It is one of the major case laws in company law. We've already been able to come across others, but here we'll come across another one that has a very nice name, known as, in this case, what? Trevor versus Whitworth. Trevor versus Whitworth. Trevor versus Whitworth. So we'll see what this particular case law states in terms of, in this case, ensuring you maintain. Of course, I've already been able to briefly mention this one. The share capital of the company must actually always do what? Be maintained. It is virtually the fund of last resort the creditors can actually be able to rely upon if today the company was to do what? To be liquidated. So we'll delve deeper into, in this case, how can you really be able to maintain your capital? You know what it means to maintain, to keep it very safely. No one should be able to tamper with it, or in this case, mess with it. It is virtually the fund of last resort that, in this case, if today the company was to be liquidated, we'll go to it. And in this case, get the money from there to be able to pay what? The creditors. And if there are any residues, then we can be able to share amongst what? The shareholders. Amongst the shareholders. So that's what, in this case, we'll actually be able to look at under maintenance. I've already been able to briefly talk about it, but now we'll delve deeper into this aspect of maintaining the share capital of the company. Then last but not least, in this case, we look at dividends. And under dividends, we'll see how, in this case, dividends will likely end up having to be proposed, declared, and eventually, in this case, done what's paid by the company. And in this case, it will likely be proposed, declared, and in this case, eventually paid by the company. So ideally, this is what, in this case, we're going to look at under what? The topic of share capital. 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 So what is share capital? What is share capital? Remember, initially, when we in this case introduced this particular unit company law, we said when we talk about a company, it is a form of business. It is a means to which, in this case, you can be able to conduct business. It's just, in this case, amongst the others you know about, like a sole proprietor, or in this case, a partnership. Like a sole proprietor, in this case, what? A partnership. Any form of business, in this case, it will, in this case, end up having to commence, by in this case, ensuring it has a key resource. Part of this key resource is, in this case, exactly what? Capital. It is capital. Part of the key resource to, in this case, set up a business is what we call what? Capital. It is capital. And then when we talk about, in this case, share capital within a company, we are having to mean it is, in this case, a means to which, in this case, the company can be able to raise what? Capital. And in this case, it arises as a result of the company having to do what? Sell shares. So the company sells shares. And then in this case, as a result of having to be able to sell, in this case, what we call what? Shares. It is able now, in this case, to raise a means of capital, which in this case we refer to as what? As share capital. So it is a means of capital for the company. How does it arise? It arises as a result of the company having to be able to do what? Sell what we call what? Shares. The company sells shares. And of course, in this case, you already know in this case what we mean by a share, because it is just the very previous topic we've been able to look at. It is just the very previous topic we've actually been able to look at. So share capital is a means through which a company can be able to raise capital. How does it arise? The company simply sells what? Shares. And as a result, it is able to raise what we call what? Capital. A company is a form of business. It can only be able to operate if it has capital. One of the key sources of capital is, in this case, what? Share capital. It sells what? Shares to raise, in this case, what? Share capital. To raise share capital. So that, in this case, what you're having to say, what? Share capital. So when the shares are having to be sold, they can, in this case, be sold at what we call what? At a premium. Or in this case, they can actually be sold at a discount. So they can actually be sold at a premium, or they can actually end up having to be sold at a discount. So when you sell shares, there's something in this case we call what? The par value. The par value, or in this case what we call what? Face value. The par value in this case what? The face value. The par value in this case what? The face value. This is like in this case the true value at which in this case the share should actually in this case do what? Be sold in the market. So that is what? The par value. And this is what in this case will likely end up having to be stated in what we call what? A prospectus. But now sometimes the company could end up having to sell these shares at an amount over and above the par value. What in this case has actually been stated as the value per share. Maybe in this case the value per share is supposed to be maybe in this case 10 shillings. 10 shillings. But now they actually end up having to sell at in this case what? 15 shillings. They would have raised 5 shillings extra, which is far much beyond in this case what? The par value. Which is far much in this case beyond what? The par value. Or the value at which in this case the shares were supposed to be sold. It is normally stated in this document we call a prospectus, that the par value, when you're having to sell the shares to the members of the public, when you've done an IPO, we are supposed in this case to sell them, we are going to sell them at in this case what? 10 shillings. But at the same time, they can also be able to state that they'll be able to sell them at what? At a share premium. When they say they have sold them at a share premium, it means in this case, they have sold the shares at an amount over and above the par value. They have sold them at, in this case, what? At 15 shillings. The amount that is actually over and above the par value is what we call what? The share premium. So what is share premium? The amount that is actually over and above the par value of a share. When the company is having to do what? Sell the shares. What you must actually be able to know, and of course I know you know this, because you are very good students of financial accounting or financial reporting. This amount raised over and above the par value, it is never in this case part and parcel of the share capital. Remember this one you report it as what? As an equity item. It is never part and parcel of the share capital. It should in this case actually be maintained in a very separate account. We call it the share premium account. I know you can be able to, in this case, even educate me or even inform me that in this case, The share premium will appear as one of the equity items in the statement of financial position. This is how it arises. These were simply amounts which were gotten over and above the par value, and therefore they keep them in a very separate account. The statute, the Companies Act, requires that if these amounts gotten over and above the share capital, they shouldn't actually be part and parcel of the share capital. They should actually be kept in a very separate account. They maintained in a very separate account, which in this case we refer to as what? As the share premium. Still the same case, under the statute, it provides that these amounts gotten over and above the par value, they shouldn't just in this case be used anyhowly. They'll be used for specified purposes. They'll be used for specified purposes. For example, in this case, if you issued out some free shares, maybe in this case you've actually issued out some free shares. There could be some free shares you've actually been able to issue out. And remember, there's something you've been able to say, that the share capital of the company should actually always do what? Be maintained. You must, in this case, always be able to realize the true value of the share capital of the company. So maybe in this case, you have actually issued out some free shares. Maybe they could be free shares you've issued out. Maybe there could be some shares, which in this case, you've issued at a discount. You've issued them at a discount. Maybe you've actually redeemed some shares at a premium, redeemed shares at a premium, Remember redemption of shares at a premium? Or in this case, you've forgotten, you have to remember we talked about it. You have to remember we talked about it. Maybe in this case, you've incurred some, in this case, what? Preliminary expenses on the formation of the company. Preliminary expenses on the formation of the company. These are part of the purposes at which, in this case, this share premium can actually be utilized for. When you talk about preliminary expenses you in this case incurred to enable the formation of the company, you can use this share premium to pay off or to defray off those kind of, in this case, what? Expenses. If in this case you've issued out some free shares, maybe it could be in this case to be promoters, it could be maybe in this case to be the most performing employee, the company. You can in this case get the amounts to cover for these free shares from what? The share premium. From the share premium. From in this case what? The share premium. Maybe in this case you've issued some shares at a discount. Now in this case at a discount is the opposite. Other than having to sell it at a par value of 10, you've sold them at a value of, in this case, what? 6. So you are in negative with what? 4. You are in negative in this case, what? 4. So because you got some amounts over and above on other shares, you take this one, you replace with this one, so that you can come at what? At par. You can come at par. The reason that's why in this case this one is having to happen, there's something in this case I'm still having to mention and repeating it. Maintenance of the share capital. Maintenance of the share capital. If you don't do this, you won't be maintaining the true value of the share capital. You won't be maintaining the true value of the share capital. In short, we're having to say that you gave out some free shares. But in this case, you are reporting in your books of accounts, you've received 10 million. Out of this 10 million, 1 million were free shares. You will need, in this case, be going against what? The maintenance of the share capital, which is virtually the only fund that can be relied upon by creditors if today the company was to be liquidated. The statute in this case requires that the share capital must always be maintained. The reason that's why in this case, you'll be able to take the share premium and replace this one. Maintenance of the share capital. You would have gone against what? Maintenance of the share capital if you don't do such. Because you got these amounts over and above, you can take them and replace. You will maintain what? The share capital. This statute, the Companies Act requires that the share capital of the company should always be maintained. It is virtually the fund of last resort that can be relied upon by creditors. If today the company was to be liquidated, where do we get the money to pay the creditors? In this case, we go to what? To the share capital. If we have not actually been maintaining them, we gave some free shares. Well, books of accounts will be lying. We have 10 million, yet we have a deficit of 1 million because we gave out some free shares. Some of others were in this case at what? At a discount. They were at a discount. And in this case, you have to take note. When I'm having to say maintenance of the share capital, you are keeping it safely. But I don't mean that in this case, the share capital is just relaxing in the company waiting for the liquidation. When you get share capital in the company, in this case, you basically acquire assets. Part of the money will basically still be in the bank account. Maybe part of these assets you acquired. When you go to the share capital, it could be inventory, it could be buildings, it could be land. That's what you're having to talk about. What? The capital is in this case represented by the assets, the inventories. That's what you're having to say, you maintain. But in this case, it's not the money is relaxing in the bank, waiting for liquidation. It is not being used for anything. No, it is basically represented by what this share capital is used to acquire, and therefore they have to be maintained, because now if the company is to be liquidated, we sell this inventory, we sell these buildings, we get the money to pay what? The creditors. It is virtually the fund of last resort that can be relied upon by creditors if the company was to be liquidated today. But the money is not just waiting. I've already been able to tell you it is represented by maybe assets, which could be inventory. When they got the money, they bought maybe machineries to manufacture products. They bought land. They built a warehouse, a godown. That godown now is what the creditors are relying upon it on liquidation. And then in this case, you're having to say, the reason that's why in this case you look at the share premium, you'll be able to, in this case, replace any shares that were actually paid for free. In this case, if any shares that were given out for free, if some shares were given out at a discount, you can be able to cover for the discount on this from this premium. If in this case you redeemed some shares at a premium, remember redemption. Well, in this case, you see, when you talk about redemption, you are simply having to buy back the shares that you actually sold. If you are redeeming preference shares, you are buying them back. Maybe in this case, you bought, in this case, you in this case sold them at maybe 10. You sold them at 10. So it means the shareholder was having to give you as a company 10 bob. So they were giving you 10 bob. But now when you are redeeming basically simply means in this case you are giving back the money, then they are relinquishing the shareholding. You are redeeming at 12. You see you are at a disadvantage because you are incurring more than what in this case you got. A shareholder gave you 10, but when you are redeeming at a premium, at an amount over and above what was the par value that in this case you received. So you have in this case like an extra shilling that you're having to incur. So you can go to the share premium and of course be able to do what? Cover up with this extra amount. Cover up with this extra amount because you can't get this extra amount from in this case what? The share capital. If you do so in this case, it means you are going against what? Maintenance of the share capital. Maintenance of the share capital. Then you're having to say, if you're having in this case to incur some preliminary expenses on the formation of the company. Maybe initially when you form the company, you can do an IPO. Then in this case, you sell some shares, in this case, at what? At a premium. So that premium can help you to pay off this kind of what? Preliminary expenses. Also, in this case, if you are doing what we call what? Share capital reduction. If you are doing in this case what we call share capital reduction. So for share capital reduction purposes, part of the approach you can use to do share capital reduction, and because we look at this one later on, you can do share capital reduction by buying back shares. You buy back your shares. You buy back your shares. You can buy back what? Your shares. So what it means in this case, you had actually been given some amount by this case what? By the shareholders. But now you want to reduce the capital. How do you reduce it? You tell them that in this case, you relinquish your shareholding, I give you back your money. So you had actually given me 10 million. I want in this case to do it, to relinquish part of this 10 million as capital because we are not having in this case to meet, like in this case, your value as a shareholder. So the shareholder value is not actually in this case optimally having to be met by the company. So we don't have to maintain all this capital. We want to relinquish part of it. And in this case, tell you guys, we don't want it to be shareholders. So therefore, we want to reduce the share capital from 10 maybe to 5. So part of it, in this case, the ways you can be able to get money to give back, it is to go to what? To the share premium. You'll get the money there to be able to do what we call what? Share capital reduction. So in short, the point you're having to drive home, sometimes the company can sell shares at an amount over and above the par value. We refer to it as the share premium. This share premium can be used for specific purposes in accordance with the statute. Part of them, in this case, we've been able to list them here. We've been able to list them here. Here. So what are the types of share capital? So in this case, you can look at the types of, in this case, share capital within the company. Types of share capital within the company. What are the types of share capital within the company? So you can have a number of them. The types of share capital within the company. Types of share capital. Types. Share capital. Types of share capital. You can have in this case what we refer to as the nominal. Sometimes this is what we call it authorized. We call it authorized. Sometimes we call it registered. Registered share capital. Then out of this, we can actually be able to have what we call issued. issued share capital. Issued share capital. There's one of our friends who is making noise. Who is that making noise? You can mute some of our friends here, because I can tell you some of the things we've had in these classes. Some of the things we've had in these classes when people are not muted, you cannot imagine. You cannot imagine, or I can't tell you. Let me not tell you, but just try to imagine for yourself. You just try to imagine for yourself. Let me not tell you. You just try to imagine for yourself. Some of the things we've had in these classes when people are not on mute, I don't need to tell you. You just try to imagine for yourself. Just try to imagine for yourself. If you imagine for yourself, you just get the answer. You just get what? The answer. You just end up having to get the answer. So in this case, you can actually be able to have, in this case, issued share capital. You can have subscribed share capital. Subscribed share capital. Then in this case, you can have unsubscribed share capital. We can have unsubscribed share capital. We can have called up. Share capital and called up. We can have uncalled up. We can have fluctuating capital. So these are some of the types we can be able to have. So the type of the capital, share capital will likely be described. By the name. Will it be described by the name? For example, in this case, when we talk about nominal, authorized, or registered, it is the share capital with which the company will be registered with at the registrar's office. So it is the share capital with which the company will be registered with at the registrar's office. When you're having to register the company, will be called upon to state which capital you want your company to be registered with. Maybe you'll say 100K, you'll say 1 million, say 5 million. So that is basically in this case what we refer to as the authorized or registered capital. The capital with which the company will be registered with at the registrar's office. So we refer to it as the registered. Sometimes we call it authorized. Is what you've been authorized by the registrar. Out of it, you can be able to issue. Maybe in this case, the registered could actually be 100,000. So you register your company with 100,000. So out of this registered capital, the capital with which you've been able to register your company at the registrar's office, then you can actually be able to issue part of it. So what you issue out of this 100,000 is what you'll be able to refer to as the issued share capital. So the issued share capital is part of the authorized share capital, which has actually been issued out to the members of the public to apply or to subscribe for allotment, or in this case, for the shares to be distributed to them. So what you have to take note here is that the issue will never be more than 100,000, because now in this case, you can never, in this case, issue what you don't have. You must, in this case, issue either what you have or less. So it can actually either be equal to, or it can be less. So the issued share capital in this case should be equal to or less than, in this case, what the authorized or registered capital. So the capital that is actually issued out of the authorized or nominal capital to the members of the public, or for subscription in this case, is what we refer to as the issued capital. So this issued capital should be equivalent to the registered, or it should be less than. It can never in this case be more than. You can't issue what you don't have. So either in this case they can issue the whole 100, or they can issue maybe 90,000. Like that. Then the other 10,000 remains unissued. Remains in this case what? Unissued. Remains unissued. Then subscribed. Once the company has actually been able to now issue the shares, maybe they have issued 90,000. So there'll be in this case applications for allotment. People will be able to apply for allotment. So people will end up having to apply in this case for allotment. So the shares which in this case, or the part of the share capital which in this case has actually been subscribed for, is in this case what we refer to as the subscribed share capital. So part of the share capital which has actually been applied for allotment is what we refer to as, in this case, what? Subscribed share capital. So if in this case it happens that it is not fully subscribed or applied for, we can have a portion of the share capital which is yet to be applied or subscribed for. Maybe they actually issued 90,000, but now people have only been able to apply for 60,000. This can arise. You know, there can be an oversubscription. Maybe people apply, so many of them, they apply the entire thing. Like in this case, when you are making the allotment, you decide how will you be able to distribute the shares. You'll have the problem of distributing. But sometimes there can occur a situation whereby you've actually been able to issue as a company 90. But now with 𝐂𝐨𝐿𝐼, so it means that in this case, you don't have enough money. People don't have money in the pocket. People don't have money in the pocket. So it means in this case, there can never be an oversubscription. So sometimes you will suffer this as a company. There can be that part of the share capital, which in this case hasn't actually been applied for allotment by members of, in this case, what the public. So in this case, you'll have what you call unsubscribed. So the remaining 30 here will end up having to be unsubscribed for. So it means that in this case, not the entire share capital has been applied for, subscribed for, you'll experience in this case that part of the capital which you had actually issued having not actually in this case to be subscribed for. So you can have unsubscribed in this case share capital, the part of the share capital which hasn't been applied for on allotment, which hasn't actually been applied for on an offer. So if in this case you're having to make an offer, then people don't apply for it. It becomes in this case unsubscribed. Then called up share capital. Called up share capital is that this is basically similar to in this case what we talked about, making a call. Making a call. There can be that part of the capital which in this case hasn't actually been paid up for. Maybe there are some amount having to outstand on this share capital. Because you say, for example, the first value of the share could actually in this case maybe be 10. Then you say on allotment, people have to pay 6. On first call, people have to pay 2. Second call, people have to pay 2 of the first value. So in total, you get 10. So this part, they're yet to in this case do what? This part they're yet to make up. Let's assume in this case they're yet to make up, which will be known as the uncalled up. Uncalled up. But eventually in this case, once they make the call, it becomes what they called up. The part of the share capital, which in this case, the company has made a notice or a request to the shareholders to be able to pay any outstanding amount. It will be the called up. So when they make the call or they give out the notice for the payment of this 2 per share, it means in this case, this portion of the share capital will now become called up. What will be remaining in this case, they haven't actually been able to make that notice or request for payment of the outstanding amount. It will be the uncalled up share capital. It will be the uncalled up share capital. And of course, companies might end up having to adapt this way of having to, in this case, raise capital because of their needs, their financial needs. Maybe initially they're having a project. Maybe they have a project. In this case, they're having to do construct a factory. And then in this case, they set up the machinery. So to construct the factory, they need to raise 6 shillings per share. So they can be able to say on allotment or on the direct initial public offer, you have in this case pay up 6 shillings of the shares applied for. 6 shillings for every share you've been able to apply for. So they want to use these 6 shillings to be able to do set up or construct the factory. Then in this case, once they are through, there'll be another need having to arise. Maybe they want to now do the machinery, to set up the machinery. They make another call. Then in this case, eventually when they are finalizing, they want to acquire raw materials. So they'll be able to make the second and the final call. The final call in this case will enable them to now bring in the raw materials. And in this case, do commence on business. Commence on business. That will be part of the reason as to why they can go for this kind of an approach, whereby on allotment, you just in this case pay part of the first value. Then when they make the first call, you make another portion of the first value, payment of the first value. When they make the final call, you make now the final payment on, in this case, the shares is as a result of the capital is of the company. So when you talk about in this case the called up capital, it is that part of the capital the company has been able to make a call or a notice to the shareholders to pay any outstanding amount. Then in this case, the uncalled up is that amount of the share capital the company is yet to in this case do make a call for the payment of in this case the outstanding amount. There could be a reason as to why in this case they haven't actually been able to make the call. Maybe in this case the need hasn't actually been able to arise. When in this case it will likely end up having to arise is when they likely end up having to make a call. Then you have the fluctuating capital. So fluctuating capital, in this case, it actually fluctuates from time to time. It will actually basically be dependent upon maybe if the shareholders are having to add in more capital, maybe from time to time, they're having to maybe in this case add in more capital, maybe draw part of in this case the capital. So it changes or fluctuates every time there's an addition of capital. When capital is withdrawn, in this case, it means probably in this case, those who are having to withdraw the capital, they might actually end up having to be charged maybe some kind of, like in this case, interest. So it will likely end up having to fluctuate. So that kind of a capital, we'll be able to call it what? A fluctuating capital. From time to time, it will likely end up having to increase. Then in this case, from time to time, it can likely end up having to be withdrawn. So it is having to, in this case, fluctuate. It's not in this case static. It's not in this case exactly what? Fixed. It's not in this case fixed in any way. So we'll be able to refer to that kind of a share capital as having to be what? A fluctuating capital, having to be a fluctuating capital, having to be a fluctuating capital, a fluctuating capital. So now I want us, in this case, we look at something we call a prospectus. So a prospectus, we've been able to say that the company is going to sell shares. But now when they're having to sell the shares, they use what we call a prospectus. So what is a prospectus? What is a prospectus? We have in this case what we call what? A prospectus. A prospectus, we have what we call a prospectus. And then we have another one we call a statement. We have what we call a statement in lieu of a prospectus. In lieu simply means a representation of a prospectus. A statement in lieu of a prospectus. So when you talk about a prospectus here, a prospectus is a notice or an advertisement that ends up having to be issued out by the company, inviting members of the public to buy into the shares. It can be shares or debentures of the company. Of course, debentures, we're going to look at it when we go to the next topic, which we refer to as debt capital. But here, let's focus at, in this case, what? Shares. Debentures, we'll talk more about it in our next topic. In this case, we call it debt capital. It's still an instrument that the company can actually be able to sell to raise capital. In this case, we refer to them as what? As debentures. We'll talk more about them in debt capital, which is our next topic. Let's focus so much in this case with regard to what? Shares. So when you talk about our prospectus, a notice, advertisement that can be issued out by the company, inviting the members of the public to buy into the shares of the company, or we're having to say also what? Debentures. So they can actually be able to give out this notice on their websites, in newspapers, radio announcements. They'll basically be out there talking about, in this case, them having to do what? Sell shares. So this prospectus will have, in this case, a number of contents. It will have, in this case, what? A number of contents. So part of the contents that will be there, quite obvious, that you must actually be able to expect, we should be able to see the name of the company. For example, in this case, if it's in a newspaper, we should be able to see the name of the company, which company is having to sell these shares. Number two, we should be able to see the power value of these shares. We should be able to see the power value of these shares. That 10 shillings we've been able to talk about, we should be able to see it. Number three, are they selling the shares at a premium, or they're having to sell them at a discount? They must actually be able to inform us. We should at least in this case be able to see, are they having to sell the shares at a premium, or in this case they're having to sell them at what? At a discount. This company you're talking about, who are the directors? Are we putting our money in safe hands? Are they in safe pair of hands? Or things might just go marambas for us. When we put in, after 2 or 3 weeks, we are told that in this case the company is no more. We have to know who are the directors of this company. So they'll have in this case to do a profile. Who are the directors? Also in this case, they have to indicate these directors, how many number of shares are they having to hold in terms of what you call what? Qualification shares. Qualification shares. Do you remember qualification shares? We said in this case, when Orlando will become a director at SAFCOM in the year 2029, in this case, he will be called upon to take up some shares at SAFCOM. Those shares, he'll be called upon to set them up. In this case, we call them what? Qualification shares. And in this case, remember we said, Orlando doesn't deal in this case with very little money, a lot of money, a lot of liquid money. So those shares, you'll be able to take them up. In this case, we call them what? Qualifications. So we are having to expect, if Safaricom gives out a prospectus in 2030, the name of Orlando should be able to appear there. And of course, they should be able to indicate he has how many number of shares. And mark you, they won't be little shares. It will be almost over 10 million shares. They have to indicate. They have to indicate the number of shares having to be held by what? These directors. The number of shares having to be held by what? These directors. But then the date of issue, when are they issuing these shares? When will people start having to scramble for them? They'll be able to indicate the date of what? The date of issue. When they are opening, in this case, what? For people to be able to do what? Apply or subscribe. They'll be able to say maybe in this case, it's exactly what? On which date can they be able to give? So maybe they can be able to say 1st of April 2026. But this 1st, can we really be sure about it? It is Fool's Day, so maybe they can be able to give a very good data. But when you say fast, it is Fool's Day. You might be fooling us. Is it a Fool's Day? People might end up having to suspect. They must be able to give a very good data, a nice data, so they'll be able to indicate the date of issue. It has to be there because you are inviting people, but they, in this case, don't know, in this case, when are they going to, in this case, start to do what? Applying for the share. So they'll be able to, in this case, indicate the date of, in this case, what? The offer, or the issue of, in this case, what? The shares. The date of, in this case, what? The issue of the shares. So the names and address of, in this case, what? The auditors of the company. Who are the auditors of this company? So they'll be able to profile or give you, in this case, what their details there. So apart from, in this case, what we've just been able to mention, there are other key reports that must actually be attached on the prospectus. Number one, the financial statements of this company, more so in this case for the last, 5 years. Number two, the dividends paid, dividend report for the company for the last, in this case, 5 years. It is very essential that in this case, this report is there. Number three, what is also very essential, assuming this company is having to raise this money for a very essential project. So the financial viability of this particular project, a report about the financial viability, reports on financial viability of some of the projects the company will likely be involved in, report on the financial viability of the projects the company will likely be involved in. Why do you think it's actually very important to put this? In this case, you're having to say, Olango is a very clever guy. He'll be asking, how has actually this company been performing, Safaricom as a company? They'll tell him, Safaricom, we've actually made 60 billion of profits consistently for the last 5 years. This company looks very attractive. That is actually giving me signs that in this case, if I put in my money, then it is really going to be able to thrive. It won't actually, in this case, just exist for a short period of time. It is like, in this case, it will be there forever and forever. My money, in this case, will likely be safe in terms of what? Investment. They'll, in this case, be asking, dividend, how have you actually been paying, declaring dividends per share? They'll tell him, oh, they also don't joke up with us. You're having to do 2 shillings per share the first year, 3 shillings per share the second year, 4 shillings per share the third year, 6 shillings per share the fourth year, 10 shillings per share the fifth year. Wow, this is very attractive. This means in this case, I can be able to put my money into this company. What are they going to use the money for? They're in this case prospecting to get into, in this case, what? Uganda as a market. Already in this case, we're in Ethiopia, but now they want more capital, in this case, to do what? To get into Uganda as, in this case, what? As a market. That looks very attractive. In terms of, in this case, assets, they likely basically be able to grow in terms of assets. It'll become a very big company. There's a lot of viability in terms of market we're in Uganda. It means in this case, the future of this company, things are just quite okay. It looks very attractive. In this case, I can actually be able to do what? Put in my money. Even if I put in that 10 billion of mine, it won't drink water. It won't drink water. So we are able to say, apart from the contents, these key reports, it is important that in this case, the company attaches on the prospectus the financial statements of the company the last 5 years, very essential. The dividends report of the company the last 5 years, very essential. In any case, the share capital is having to be raised to invest into a viable project that in this case, probably in this case, can be able to bring in a return. There has to be a report by a special accountant having to indicate the financial viability of that kind of, in this case, of a project. Because any person having to buy shares in a company, he's an investor. His intention basically in this case is looking at what is the going concern of this company, like in the next or near future. I must actually end up having only to be able to, in this case, do what? Put in my money. If in this case, I can be able to ascertain what? These reports are actually there, and in this case, they're having to satisfy me. Remember, these financial statements you're having to talk about, they must in this case be audited. Not just financial statements, audited. Audited financial statements by what? By an auditor. And he has actually been able to certify them. So that in this case, if it happens, we put in our money and we rely on these financial statements, who will be asking questions? The auditor. The auditor, and of course, in this case, I know in your auditing and assurance, you must have learned something about it, or about what? The auditor's liability. This is how it can be able to arise. This is how it can be able to arise also. An investor can question, I relied on these reports to buy shares in Safaricom. These financial statements were certified by this auditor. He is one of the experts, in this case, who I relied upon when I was having to make what? A decision. So he sues the auditor for, in this case, what? Is it civil, or you can also say criminal? Is it civil, criminal, or statutory? In this case, what? Liability. So like that. So it become in this case what? Liable. So this, the essence of in this case, what? Putting on this prospectus what? These reports. So apart from the contents, part of the other accompaniments or contents that in this case will be found in this case in this report are these ones. And I've already been able to explain the reason as why in this case they'll end up having to put them up there is because now in this case, a person having to make an investment in the company in terms of buying shares, this is what he'll likely basically be looking at to be able to do what? Make an informed decision. And part of, in this case, the experts will likely be involved. For example, in this case, on the financial statements, it is the auditor. The financial statements attached there, they should actually, in this case, be certified by the auditor. So we have this on, this is what we call what? A statement in lieu of a prospectus. A statement in lieu of, in this case, what? A prospectus. Sometimes the company might actually, in this case, go for the approach where they don't want to go public, announcing everywhere that in this case they're having to sell shares. They can, in this case, take an approach where they approach key investors who, in this case, they know for sure they can end up having to buy the shares of the company without having to make a lot of noise out there in the public. Then they can issue to them something we call a statement in lieu of a prospectus, a representation of a prospectus. In lieu simply means a representation of, in this case, what? A prospectus. It will have similar contents to, in this case, what? A prospectus. The only difference is that in this case, it will basically, in this case, be done what? Privately, without having to make a lot of what? Noise out there in newspapers or everywhere. They just know this kind of a guy can actually be able to buy shares. So they actually approach him and actually inform him, in this case, what? Or what is actually happening in the company. They convince him, and in this case, eventually he does what? He can end up having to buy what? The shares of the company. So when you talk about this statement in lieu of a prospectus, it is a representation of a prospectus. Only that in this case, the company doesn't actually issue it out publicly. It approaches key investors in the economy privately, and in this case, convinces them with the same contents in a normal prospectus, in this case, for them to be able to do what? Buy the shares of the company. We call it a statement in lieu of a prospectus. A statement in lieu of a prospectus. There's something now in this case we call what? A misleading prospectus. A misleading prospectus. A misleading prospectus. A misleading prospectus. There's something we call a misleading prospectus. What is a misleading prospectus? Just from the term mislead, it is causing a lot of confusion. It is causing a lot of confusion. We are wondering, in this case, why did we invest our money? Is because you were lied to. We were lied to in the prospectus that the company, in this case, is making a dividend of 10 shillings, is paying a dividend of 10 shillings per share. And in this case, we did what? We put in our money. By that time, in this case, is when Orlando is having to realize, Kime Muramba. In this case, Orlando, in this case, will have certain remedies. It can't just go like that. Orlando will be able to say, in this case, because you lied to me, guys, I'll deal with you. I'll deal with you. So in this case, when you talk about a misleading prospectus, it is a prospectus that contains misrepresentation of facts. Misrepresentation of facts. What is contained there is not true. Misrepresentation of facts. A prospectus that contains misrepresentations of facts. Misrepresentation of, in this case, what? Of facts. Remember, this particular prospectus is what forms the basis of agreement or contract between an investor, a shareholder, and in this case, what? The company. If it happens, what was actually contained there, the contents, some of them in this case were not factual, were not true. Then in this case, we call that kind of a prospectus as having to do what? A misleading prospectus. A misleading prospectus. A misleading prospectus, we call it a misleading prospectus. It contains what? Misrepresentation. It contains what? Misrepresentation of, in this case, what? Facts. You know, in this case, statements that are in this case found in a contract, we call them representations. Statements found in a contract, we call them what? They are making representations about what? The agreement. Statements in a contract, we call them representations. If it happens, these statements are not true, then we say they are misrepresentations. So it means in this case, what is having to be contained in this kind of a prospectus, it is not true or factual about the company. It is just having to lie to what? The potential investors, maybe to dupe them to be able to buy the shares of the company. We are having to say, like in this case, Orlando is having to be lied to, that the company is having to pay 10 shillings per share as dividend in those attachments we've been able to talk about. Then in this case, he's blind. He thinks, like in this case, because the auditor certified it, The things are okay. Let me put in my 10M to get 10 shillings per share as dividend in the coming financial year. Maybe in this case, they would be at what? 11. Maybe they have actually said in this case, they are going to in this case do what? Expand into in this case what? Uganda. He puts in his money. He waits the first month, second month, third month, fourth month. Nothing like that is having to happen. Or maybe in this case, they of course invest in Uganda. But I think in this case, when they invest there, things now in this case start going haywire. Things are having to go marambas at Safaricom as a company where he had in this case a lot of hope. Now they have started making losses. So this basically in this case is having to raise questions. This guy is lying to me. So in this case, this is what I saw in the prospectus. It was very attractive. But now in this case, things are not okay. What am I going to do? So if that happens in this case, under the law, such kind of an investor will have what? Certain remedies. He has remedies. He has in this case what? Remedies. These remedies are usually categorized into two. There are those remedies against in this case what? The company itself. He can go for the company itself. And in this case, number two, we've been able to say sometimes in this case, you can be able to have what? Experts who are involved in having to do what? Prepare the prospectus. In this case, we can have what? Auditors as having to be part of the experts. But in this case, more so, these prospectus as part of the contest, it is normally signed by directors. Directors are the ones in this case who are like on top of things. In terms of, in this case, what? Preparing the prospectus for the company. They are the ones who sign it off. So that in this case, it can actually be put out there. So part of the parties who can actually be liable for anything that is actually contained there, number one, it is directors. Mabazu wa company, directors. Then in this case, apart from directors, we can actually in this case be able to have what? Auditors or other experts. Experts like in this case, what? Auditors. Let's assume in this case, this company was just having to be formed. And now in this case, the person who like in this case be on top here, will be in this case what? The promoter. The promoter on a company having to be formed, it is the promoter. Remember in this case, you see one of the duties of a promoter, if in this case is having to form a public company, then he'll actually be involved in the initial prospectus that will actually be prepared by the company to invite people to buy the shares of that public company. So the parties who can actually be liable, in this case, these are misleading prospectus. It can be directors, it can be experts like auditors, it can be promoters. Experts, they are in this case involved, for example, in having to come up with some of the reports that in this case are actually attached on, in this case, what? The prospectus. Attached on, in this case, what? The prospectus. So in the exam, they can be able to ask, who are the parties who can be liable for the contents of our prospectus? 3 marks. So don't start having to say this is Greek. I've not seen it anywhere. We just say directors, experts, and promoters. Don't say this is Greek. I've not heard it anywhere. Just say it. The parties who can be liable for the contents of our prospectus, or the parties who can be liable for a misleading prospectus: directors, experts, promoters. 3 marks, cool marks, 3 cool marks, 3 cool marks, 3 cool marks, 3 cool marks. So overall, what you're having to say that any investor who has actually basically been misled by a misleading prospectus will have in this case what? Remedies. In this case, you have the remedies against the company, and those ones against in this case what? Directors, experts, or in this case what? Promoters of the company, promoters of the company. So you can in this case look at the remedies that in this case you'll be able to have against in this case what? The company. The remedies that in this case you'll be able to have against what? The company. So the first remedy he'll be able to have is what we call rescission, to resign, or in this case to avoid this kind of what? A contract of allotment of shares. So number one, he can be able to resign. He can in this case resign the contract. Can resign the contract. Or in this case, he can actually be able to sue for negligence. For negligence, sue for negligence. Or in this case, sue for recovery of damages or losses suffered. Sue for recovery of damages, recovery of the damages or losses suffered. Losses suffered. You lost money. So you lost money because now in this case, you thought things will be okay. You thought in this case what? Things will be okay. These are the 3 key remedies. Against what? The company. So he can resign or avoid the contract allotment. He can sue for what he called negligence. This negligence, you must have learned about it in your law and governance. He can sue for recovery of damages or losses, in this case, what? Suffered. against what? A key officer of the company, like a director, like that. Or in this case, if he can be able to prove an official officer of the company was involved in that misleading prospectus, he can sue for recovery for any loss he has suffered as a result of relying on that, what, in this case, prospectus. So when you talk about, in this case, having to resign or avoid the contract of allotment, so he, in this case, like if the shares have already been allotted, so in this case, he relied on the prospectus, they have done an initial public offer, he got the prospectus, he subscribed for them, they have already allotted. So you can, in this case, resign and actually say that I do not want, in this case, to do what? Have these shares. I not, in this case, want to have these shares. I've just realized that in this case, I was actually misled by your prospectus to buy these shares. And therefore, I don't want, in this case, to be part and parcel of this kind of an agreement. He'll be given, in this case, that right to avoid what? The contract. And therefore, in this case, it means he'll be able to recoup back his what? Money that he had actually been able to do what? Invest in the company. That in this case, he had actually been able to do what? Invest in the company. And to be able to resign, he must actually be able to prove that this particular prospectus, indeed, it was actually issued by the company. Number one, he must prove it was issued by the company. So he provide evidence that the prospectus was by the company. Number two, he must actually be able to prove that he actually relied on it. In this case, he relied on it, and that is what, in this case, really convinced him to be able to do what? Buy the shares of the company. He, in this case, ended up having to do what? To rely on it. He relied on it to be able to do what? Make an informed decision. Number three, he can pick out that misrepresentation. He can pick out that statement which was not, in this case, correct in what? The prospect that was lying about the company. He can really pick it out. And in this case, be able to produce it as part of, in this case, the evidence. This is what you said, and in this case, is not actually true, or in this case, factual about what? The company. With him having to be able to prove this, then he'll be able to avoid or cancel out or resign, in this case, what? The contract of, in this case, what? Allotment of the shares. Allotment of the shares. So he must prove those. But in this case, number one, it was issued by the company. Number two, he relied on it. There was a statement, in this case, he relied upon it to be able to make what? An informed decision to buy the shares of the company. Number three, the statement he relied upon it, in this case, it was not, in this case, true, or maybe in this case, factual about the company. And therefore, it is one that, in this case, convinced him to be able to do what? Buy the shares. With him have to prove those, then in this case, he can be able to do what? He resign or avoid, in this case, what? The contract of allotment, and they have to give him back what? His consideration, the price he paid for the shares. But you'll have to give me back my money. I don't want your nonsense. You'll basically be shouting at the office of the company, telling them, you people are nonsense, so you have to give me back what? My money. You have to give me back what? My money. I can be able to prove this. You have to give me back what? My money. Like that. But now, there can be sometimes situations whereby he can lose this right. Loss of right to resign. There's a situation where he can lose the right to, for example, to resign. For example, number one, the reason that's why he might lose. Number one, by his conduct, he has already, like in this case, affirmed the contract of allotment. How does he affirm? How does he affirm? He affirms by, in this case, already having started enjoying the dividends of the company. He affirms, in this case, by having to, in this case, attend the meetings of the company. He affirms by, in this case, having to vote at the meetings of the company. He has already, in this case, started having to enjoy the rights of the company. So by his conduct, it can, in this case, be concluded that, in this case, he's like, in this case, he has affirmed. Mambo iko sawa. Mambo iko sawa. So iko sawa, so no problem. I can eat these dividends. So he has already, like in this case, affirmed it. So you can lose this right to it. Means you have to do it within a reasonable time. So if he fails, number two, if he fails to do it within reasonable time, if he fails to do it within reasonable time, then in this case, it means if it takes a very long period of time, this can arise. Number one can arise. For example, you can now, in this case, do to affirm it by starting to enjoy what? The membership rights. It's like you've already been able to ratify it. So you're enjoying dividends, you've taken 1 year, 2 years, you haven't raised any question. Then after the third year is when you are bringing this kind of a question. So you might end up having to, in this case, do to lose the right to avoid the contract of what? Of allotment. Number two, if in this case you don't do it within a reasonable time, don't wait for such, in this case, a very long period of time for you to, in this case, seek for resigning or avoiding the contract of allotment. It must, in this case, be within what? A very short period of time after allotment of the shares. After the allotment of the shares are actually, in this case, done what? Been done by the company. Then, number three, where restitution integra is not possible. What that means, you cannot actually be returned back to the original position. Where restitution integra is not actually, in this case, not possible. Like in this case, Olango Olango has already, in this case, been able to transfer his shares to, in this case, what? Francisca. Francisca is one of, in this case, what? The parties Olango sold to what? The shares there. So in this case, Olango has already lost. He can't be returned back to the original position. Maybe the person could actually be able to end up having to, maybe in this case, complain. It could be Francisca, but he has to prove he relied on what? The prospectors. So when we can't return him back to the original position, he has already transferred the shares to another third party. In that case, automatically, Olango loses the right, in this case, to do what? To resign the contract of, in this case, what? Allotment of shares. Where restitution in Instagram is not possible, you cannot actually end up having to return back to the original position. By how? In this case, you've already transferred the shares to another party. Then number 4, if in this case you have a person of, in this case, an experience, that in this case, your capacity and in this case, capability, and your experience shows that in this case, there's no way you could have actually been duped by the prospectors. Had you made further inquiries, in this case, you could have actually been able to know that in this case, that kind of a prospector is exactly what? Misleading. Then you also, in this case, lose what? The right to resign or avoid what? The contract of allotment. So that's, in this case, part of the reasons as why, in this case, you could actually end up having to lose the right to resign or avoid the contract of, in this case, what? Allotment of shares against what? The company. Remember, Francisco, we are looking at remedies against the company. Number 1, being able to say resign or avoid the contract. Number 2, having to say you can sue for negligence in a court of law. And number 3, you can be able to sue for recovery for any damages or losses suffered. So long as, in this case, you can be able to prove an official officer of the company was responsible for that misrepresentation. And therefore, the company should do what? Be liable for its officers. Should be liable for its officers. Should be vicariously. You say what? Vicariously. Vicariously liable. Vicariously. 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 Vicariously liable. So vicarious liability. Vicarious liability, you also learned about it under the law of tort. You learned about something under the law of tort, what we call as negligence and vicarious liability. So the agents of the company, who are the officer, can make the company itself to be liable because they are officially appointed by the company. They act as the agents, as the officers of the company. So the company becomes vicariously liable. So negligence, in this case, negligence is something you must have actually been told about negligence. There are 3 elements about negligence. There are 3 elements about negligence that, in this case, you cannot be able to use, in this case, to sue a party before the court of law. Number 1, you have to prove the party had what? A duty of care. Number 2, in this case, he failed on the duty of care. Number 3, in this case, you suffered a loss. You must prove, in this case, as an investor, you suffered a loss. If you can't prove number 3, don't go for negligence, my friend. Maybe try these other ones. You will succeed. But if you can't prove, in this case, you suffered a loss, then if you bring that before the court, you won't actually be able to succeed to sue for, in this case, what? Negligence. So in this case, if you can be able to prove that an official officer of the company had a duty of care, like in this case, a director, then this director actually failed on that duty of care to giving you the right information in the prospectus. Then as a result of that, uliekelea kama bet. Then in this case, ikaungua. In this case, now you can be able to sue for what? For negligence. So you must prove the 3. There was a duty of care. Failure of the duty of care resulted, in this case, for you to end up having to do what? Suffer a loss. As a result of this, you can sue for negligence to be able to do what? Recover your losses or damages against what? The company. So those are part of, in this case, the remedies against, in this case, what? The company itself. So resign or avoid the contract, sue for negligence, sue for recovery of damages or losses suffered as a result of, in this case, relying on what? The misleading prospectors. So you can take a break. Then in this case, you can actually be able to come back and actually be able to finalize on what are the remedies you have, in this case, against what? Directors. Then in this case, you can be able to look at other issues like methods of issue of shares. A break of 5 minutes should be adequate enough for us to be able to relax. Then we come back. Yes, welcome back. So confirm whether we can continue or we can go to sleep. So there are either two things. We either continue or we go to sleep. We either continue or we go to sleep. So do we continue? You can simply say yes. You can simply say yes. Do we continue? You can simply say yes. Yes, of course. You can say yes, of course. So I can see you're saying yes. Francisca, you're saying yes. Yes, of course. Yes, of course. Yes, continue. I thought even Ezekiel could say no. I thought even Ezekiel could say no. Well, but we have to continue. But we have to continue. Everyone is having to say yes. So what do we do? You are the boss. So we have no option, but we have to at least to do what to continue. We have no option, but we have to do what to continue. We have to continue. We have to continue. Everyone is just saying yes, 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 yes. So we are saying in this case, we can look at what remedies that in this case, the investor has against directors, promoters, or in this case, what experts. So if these experts in this case were in any way involved or part and parcel of, in this case, a misleading prospectus having to be published by the company, then the investor was actually being duped as a result of the misleading prospectus. You can, in this case, sue for fraud. You can actually sue for fraud. You can actually, in this case, sue for fraud, or in this case, you can actually sue for criminal liability, for criminal liability. For criminal, you can sue for criminal liability. You can, in this case, sue for criminal liability. Then also, you can actually end up having, apart from having to sue for fraud or sue for criminal liability, you can, in this case, sue for damages for misrepresentation. So you can sue for damages. Sue for damages for misrepresentation. So damages for misrepresentation. Damages for misrepresentation. So sue for fraud. So you can in this case go to a court of law, in this case sue them for having been involved in this case in what you call fraud. So what we mean by fraud here, they like in this case intentionally put that statement to defraud an investor. They did that intentionally. So these parties who could be auditors, but they might have actually ended up having to collude. They put their misleading information so that the investor can be able to buy, so that they can be able to defraud. So if you can prove in this case it was done fraudulently, it was done in this case what fraudulently, then in this case he can actually be able to go to a court of law and sue and actually be able to prove it was in this case done with the intention to defraud him as an investor. Then criminal liability. So in this case, if they end up having to breach any requirements of any statute law, if they end up having to breach any requirements of any statute law as directors, promoters, or experts, then in this case, the person who has actually been able to suffer loss can actually be able to sue for what? For criminal liability. So you can actually end up having to sue for criminal liability. And as a result of this, it means these parties will likely be done what? They can be penalized. They can be penalized, they can be fined, or they can be imprisoned. These are part of they can actually be fined or imprisoned. These are part of the remedies in this case under what? Criminal law. So in this case, these parties have breached any law. Then in this case, you can actually be able to sue them for breach of that particular law, as he was having to deal with them with regard to the prospectus. Then the court can actually be able to penalize these officers. They can either fine them, fine or penalize, or in this case, imprison them, end up having to imprison them. Then if he can be able to prove he suffered any damage or loss as a result of that misrepresentation, then he can prove that statement. You can prove that statement that in this case was not factual, or maybe in this case was true about the company that led him to be able to do what? Suffer a loss. And as a result of that, the parties will likely end up having to be liable for the misrepresentation. So if it happens, it is directors who are in this case involved. If you're a director, maybe umejipata kwa hiyo mix, there's a way you can be able to defend yourself before a court of law. So there's a way you can actually be able to defend yourself before. Let's assume in this case you're a director. And in this case, you've actually been sued for misleading prospectus. How do you defend yourself? What are some of the defenses you can actually be able to plead before the court? So number one, part of the defense you can actually be able to utilize before the court. You in this case indicate that you are not in this case aware of this misleading statement or this misrepresentation. And once you are aware of it, you actually in this case withdrew. You actually in this case withdrew from having to be the director of the company. So this misrepresentation led you in this case to having to withdraw from having to in this case be the director of the company before the prospectus was actually done issued. So you can be able to prove that in this case we withdrew in this case from having to serve as a director of the company before the prospectus in this case was actually issued, or in this case became public. Before in this case it was actually issued, or in this case did became public. Number two, what you can be able to do as a director, you can in this case speak before the court. In this case, you relied upon a statement from an expert, and therefore that statement in this case informed you to in this case maybe put a certain content in the prospectus which has actually made you to be liable. For example, it could have been an auditor. So you're not in this case the auditor is having to lie to you. So you rely on his information. Then in this case, you did you published that information in the prospectus. So that way you can actually be able to defend yourself. Number three, another way, you rely on in this case on information of an official person or officer of the company. Maybe it can be the company secretary. So he actually in this case advised you as a director as an official officer of the company. Maybe it was in this case the lawyer of the company. He advised you, then in this case you relied on his statement. And then in this case, as a result of that, you actually ended up having to do sign off or approve the prospectus. So if this happens that in this case you are liable as a director, those are part of the reasons why in this case you can actually be able to defend yourself. But in this case, you are not aware of this misleading statement. Once you are aware of it, in this case, you withdrew your consent from having to serve as a director before the prospectus was actually in this case done issued or made public. Number two, you relied upon information from an expert who in this case was able to in this case guide you in terms of having to include that statement in the prospectus. Number three, you relied upon information over an official officer of the company, an official person, be the finance manager, the human resource manager, and then in this case, from his statement, in this case, you're able to rely on his information to be able to do publish certain information in the prospectus. So with those then in this case, you can actually be able to do defend yourself as a director of the company, as a director of, in this case, the company. So when shares are having to be issued, there's something in this case we call there's something we call brokerage. There's something in this case we call brokerage. Sometimes in this case you can actually end up having to involve parties to support you or assist you in having to sell the shares. We call them stockbrokers. Stockbrokers. So they likely in this case facilitate by having to in this case maybe get clients. You'll end up having to get in this case clients. So as a result of this, you'll likely be able to pay them like a fee, or maybe in this case, a commission. So we call it in this case brokerage. We call it in this case brokerage. So in this basically in this case a fee or amount that will likely end up having to be paid by the company to parties who end up having to facilitate or enable the company to be able to sell the shares. So they pay them what you call a brokerage. They can be stock brokerage firms, or in this case investment companies. So in this case, have potential clients who in this case can be able to buy your shares. So maybe they actually convince them to buy the shares of you as a company, because sometimes maybe selling the shares can be a challenge. So then in this case, you involve stock brokers. So they facilitate or enable you because they have in this case a base. They have actually been registered in investors who in this case have invested in other companies. So they in this case use those networks in this case to enable you to do to sell the shares. As a result of this, you'll likely be able to pay them what you call a brokerage fee, or you sometimes just call it brokerage. Then we have in this case also to call an underwriting commission. Underwriting commission. This in this case something you've been able to say that you can in this case float your shares for subscription. Then you experience what you call under subscription. Maybe in this case, as you're having to say, you offered 90,000 shares. You want to raise this capital because you want to really fully up. Maybe each and every share is having to go for 100. So this means you are anticipating, you are targeting in this case, 9 million. But now in this case, only 60,000 shares are subscribed for. It means you'll have a deficit here of 30 million to undertake the project you intended with the capital you're having to raise. To avoid this one from having to arise, then in this case, you can involve people we call underwriters. So the underwriters in this case give the assurance to you as a company In case of any under-subscription, they'll take up the deficit of the undersubscribed shares. So as a result of this, it won't be for free. You'll likely pay them something. We call it underwriting commission. We call it underwriting commission. So underwriting commission is, in this case, the fee or the commission paid to underwriters for having to be able to give assurance to the company. They'll take up the undersubscribed shares. The undersubscribed, in this case, shares. So therefore we call it an underwriting commission. An underwriting, in this case, commission. An underwriting commission. So this underwriting commission will have to, in this case, be authorized by the company. Maybe through, in this case, its articles. They can be able to indicate, in case of any issue of shares, then it is allowed. The company can be able to involve underwriters. So that in this case, things don't go marambas for them, in this case, when they're issuing the shares. Because if they get a deficit, then this capital won't actually be enough for them. It won't be enough for them. So in this case, the underwriter simply basically does takes up, in this case, this amount. He takes up that amount that in this case has actually not actually been subscribed for. So we call it, in this case, underwriting commission. Underwriting commission. Underwriting commission. Then there are methods as well. In this case, the company can be able to issue these shares. The methods as how the company can be able to issue these shares. The methods of issuing the shares. The methods. How can they be able to sell these shares? The methods. So they can, in this case, do what we call a direct offer. Direct offer. They can do a direct offer. Number two, they can, in this case, do something we call placing. We have, in this case, placing. We have, in this case, placing and offer for sale. So we have, in this case, offer for sale. Offer for sale. Then you have, in this case, tendering. You have tendering. Then you have, in this case, number four, it's placing. Number four, it's placing. Then you have, in this case, what we call a rights issue. They can do a rights issue. So these are the methods as well the company can be able to, in this case, sell the shares. They can do a direct offer. They can do what we call offer for sale. They can do what we call tendering. They can, in this case, do what we call placing. They can do what we call a rights issue. A rights issue. So the methods of issuing shares. When you talk about a direct offer, is where the company itself directly sells the shares. They do, in this case, a direct offer by having to sell the shares by themselves, as in this case, as the company. So what happens here is that the company will fully be involved in having to do prepare the prospectus. Then in this case, they issue out the prospectus. Then eventually they do they invite people to buy the shares. They invite people to buy the shares. So they will, in this case, directly be involved in having to do issue. They'll be directly involved, in this case, in having to do issue the shares by preparing everything by themselves. In this case, the prospectus, which means in this case, directors will be fully be involved. They'll actually fully be involved in having to do prepare the prospectus. I don't know what Jenny is saying. Dear Malim, could therefore be an error with the statement under underwriting commission? What is the error? What is the error? What is the error? I have to unmute you. I have to unmute you. Yes. What is the error? I've unmuted you.
Yes, Mwalimu, what I was the statement under underwriting commission, a public which invites the public to subscribe for its shares. Could it be the company which invites the public, or it is the public which invites the public?
So
if you look at the handout.
Yes, it's supposed to be a public company. Just correct there. Yes, a public company which invites the public to subscribe for its shares or debentures must ensure that the issue is fully subscribed for by the public. So to ensure that this happens, it may pay an underwriting commission on all shares or debentures offered to anyone who guarantees that if any of the shares are not taken up, he will take them up before paying the underwriting commission. So you can correct there. That was the issue.
Okay, thank you.
Yes, thank you so much. Thank you so much, Jill. So I think now we are together. then they have given their part of the conditions. So it must be approved by the articles. It shouldn't actually, in this case, exceed 10%. Then in this case, the number of shares to be underwritten must be disclosed in the prospectus. So like that. Yes, I think we are together now. So we are saying in this case, direct offer is where the company is directly involved in having to do what? Sell the shares. And therefore they'll be able to do what? Prepare the prospectus by themselves. That is a direct, in this case, what? Offer. Then you have offer for sale. So what happens under offer for sale? The company sells all its shares to an issuing house. An issuing house now, in this case, it could be these stock brokers or maybe investment companies. So to an issuing house, which now in this case fully is now involved in preparing the entire prospectus. This one is advantageous because the company now in this case even avoid what? The issue of being involved in what you're calling what? Under subscription. Because they would have already sold all the shares. So this company has already been able to pay the company. Then for them, what they do, they'll in this case be involved in the entire process of issuing out the shares. So this one is advantageous because it relieves of the company, majorly the management, to be involved in other issues. They won't be getting involved in the preparing prospectus, which can take a long period of time. The management will likely be able to focus on the important issues of the company. So all these things about preparing prospectus are left to the issuing house. And in this case now, the issue of under subscription in this case is well taken care of because the issuing house has already been able to settle the amount with the company. And therefore, the trouble about preparing the prospectus, consuming a lot of time of the management, they can be able to focus on other issues. The issuing house would have taken up the risk. Already taken up what? The risk of what? Issuing the shares. So under offer for sale, all the shares in this case of the company are sold to an issuing house, which now in this case takes up the mandate of preparing the prospectus and now fully having to do what? Sell the shares by itself. In this case, it is advantageous because it actually saves time for the management to focus on the key business of the company, other than having to be involved in having to do what? Prepare the prospectus. Then in this case, you have tendering, which is not that very common. But now in this case, this is what will happen under tendering. Under tendering, bids are invited. What do you mean by bids here? People actually end up having to, in this case, put in their proposals as to how much they can be able to buy the shares of the company at. Maybe someone will be able to say, and actually say, I can be able to buy at 15. Another say, I can be able to buy at 20. Another say, I can be able to buy at maybe 21. So the one in this case who puts in the best bid or maybe proposal that in this case suits the interest of the company is the one who will likely be allowed to do what? To buy the shares. That is in this case what we call what? Tendering. Then placing. Still the same case. The shares are in this case done what? Given out or issued out or sold to in this case what? An issuing house. Then what the issuing house does, it doesn't in this case just sell to any person. It doesn't just sell to Tom, Dick, and Harry, just any person. But what they do here, they actually identify key investors who are in this case likely to buy the shares in huge blocks or in blocks that in this case are of high value. Like in this case, they could be able to identify what? Maybe NSSF. They have a lot of money each and every month that you are being deducted. We remit there. So they do investments, hoping that in this case, when you retire, we'll be able to get some money there. Maybe it could be insurance companies. They collect, in this case, a lot of premiums. So they target such, and in this case, place the shares with them. Place the shares with them. In this case, we are having to say under placing. The shares are still, in this case, given out or issued out to an issuing house. The issuing house identifies investors within the economy who can be able to, in this case, buy the shares in huge blocks, not in small amounts of shares, like individuals who could be able to buy for 10,000, 20,000. No, that is not what in this case they're intending to do. For them, they have, like in this case, already identified key investors. They'll be able to approach them and place with them and tell them, in this case, we are selling shares. You just buy them in huge blocks, like in this case, 20 million, 30 million, 50 million, 100 million, and we close this chapter. We don't want, in this case, to go to a lot of time waiting for people to apply. They might apply. We don't actually get what we want. They place them. Then rights issue. What happens under rights issue? The company goes what we call what? Internal marketing. Internal marketing in the sense that in this case, they don't invite any outsider. But in this case, they actually convince the already existing shareholders to buy extra or more shares in the company in proportion to their already existing shareholding in the company. We call it a rights issue. We call it in this case what? A rights issue. So they don't actually in this case go out, like maybe throw a prospectus out there. So what they do in this case, they actually just convince, or in this case, invite the already existing shareholders and actually inform them you can get extra or more shares within the company in proportion to what in this case you already have as a shareholding in the company. In most of the instances, what will happen here, they'll convince them to buy these shares by giving them a discount. So this is one of the exceptions where, in this case, now shares can actually be issued at a discount. They can actually be issued at a discount. They can be issued at a discount when the company is doing a rights issue. Of course, we'll be able to look at those exceptions, but this is just majorly one of them. They can give the already existing shareholders a discount and tell them, you've been with us. You've given us capital for a number of years. You don't have to buy the shares at, in this case, what? 10 shillings. You just buy at, in this case, what? 6 shillings. So that in this case, they can convince them to get extra or more shares in the company. So they can give them, in this case, what? A discount. So that's still, in this case, one of the means as to how the company will be able to raise capital, or the methods through which, in this case, they can be able to sell what? The shares. So we can have direct offer, offer for sale, tendering, placing, rights issue, rights issue, rights issue, rights issue, rights issue, rights issue, rights issue. So repeat, offer for sale. Offer for sale, the company sells all the shares to an issuing house. What is an issuing house? A company, or in this case, like a stock brokerage firm that in this case is involved in matters of selling shares for companies. So they sell to them all the shares. The company in this case would have actually been able to relieve itself the risk of, in this case, for example, having what? An under subscription. The company that is having to buy the shares the issuing house has already settled with the company. So it will be their trouble for them in this case to prepare the prospectus by themselves. It is not the company. It is not the company. The advantage of offer for sale, the management of the company is relieved of this hulabaloo, left, right, and center of preparing a prospectus, consuming a lot of their time. They will really be able to focus on the key matters of the company. On the key matters of the company. Because now, the company that in this case will be involved in having to sell the shares, it will be the issuing house. Offer for sale. All the shares are sold to an issuing house, which now in this case in turn prepares the prospectus, and now in this case sells the shares on behalf of, in this case, what? The company. The advantage, it saves time for the management of the company to concentrate on key matters of the company. It relieves of the company the risk of, in this case, under subscription, because all the shares would have already been sold to what? The issuing house. How will they be able to sell it? It is their problem. It is their problem. It is their problem. How they be able to sell it then? It will be their problem. It will be their problem. It is not our issue. It is not our issue. It is their problem. It is their problem. So that in this case, some of the methods that in this case will likely be used in having to do what? Sell the shares. Sell the shares. And of course, for today, we are going to end there. So hopefully on Wednesday, we'll be able to wind up these topics. So I really want in this case we wind up on Wednesday. So let's hope we'll be able to clear. So on Wednesday, in this case, we'll be able to look at maintenance of share capital, the ruling share versus Whitworth, then dividends. Then I'll be able to touch on, in this case, the variation of class rights. There's something about a variation of class rights. I'll be able to touch on it. Then, of course, also in this case, allotment of shares. How is allotment of shares now done? Once they have actually been able to issue out a prospectus, people are applied. How does the company do in this case what we call the allotment, then the variation of class rights, then maintenance of share capital, predominantly under maintenance of share capital, look at the Rodin share versus Whitworth, then the reduction of share capital, and in this case, eventually we look at dividends payments by the company. So hopefully on Wednesday, we should actually in this case be through with the topic of share capital. Any question you can actually be able to ask, but let me end there for now, because now it is time to go. It's time to go. It is time to go. It is time to go. Quiz. So what do you mean by quiz, 𝐂𝐿? What do you mean by quiz? Yes, so that is still one of the ways as far in this case also they can be able to do it. They can give them at a discount. But of course, you remember we've been able to say that even if you give the shares at a discount, you need to look for another way how you'll be able to get that money. You can go to the share premium. So it can still basically be the way, as far in this case, they can actually be able to do the placing. They can do what? The placing. Or when they're using a statement in lieu of a prospectus to convince private investors. So they can be able to use that method to convince them. It is just a representation of the prospectus. What do you mean by a statement in lieu of a prospectus? A representation of the prospectus, but it is issued out in a different way. It is basically issued out privately. It is issued out privately, not publicly, but privately to potential investors. It is issued out privately. The way in this case it is issued out, it is very private. So they just, in this case, identify. The company already knows this person can invest. They approach him privately, not publicly, privately. A statement, they'll give him what we call a statement in lieu of a prospectus. Sometimes we call it a breached prospectus. A breached prospectus. That's what we mean by that. We call it a breached prospectus. Any other question? Any other question? Any other question? Any other question? If there isn't, then in this case, let's go to sleep. Let's go to sleep. Is it the same as right issue? What do you mean by that, Edward? Edward. What do you have to say the same as right issue? What are you having to say is the same as right issue, then, Edward? Doris had that quiz. So what is the quiz? Doris had a quiz. Doris had a quiz. Doris, let me unmute you. Doris, I've unmuted you. Doris, I've unmuted you.
All right, thank you, Mwalim. My quiz, it's based in the methods of issuing shares, and among the methods of issuing shares, number 2, it's offer for sale. So among in that point, can we say that advertising is a form of methods of issuing shares, whereby that is advertising stroke offer for sale, whereby like offer for sale, they just publish a prospectus to the public, just showing probably the whole offer they have. So I was asking whether advertising can also be used instead of offer for sale.
Instead of offer for sale. But in this case, when you talk about advertising, it's a bit broader. So advertising is actually a bit broader. Because still even under direct offer will advertise. Because in this case, you see the definition you're having to talk about, in this case, a prospectus. What is a prospectus? A notice or advertisement issued by the company inviting members of the public to buy into what? The shares. So advertisement in this case will likely be very broad. So it won't actually, in this case, suit for you to give it as an alternative of offer for sale. Don't do such because it is very broad. Because in this case, still here you're advertising. Even when you're doing tendering, you go out there, you like put your information public there, invite people to bid. You can still put your stock advertising. So it is very broad when you say in this case advertising. So in this case, you're looking at the method, don't say advertising. Instead of offer for sale, just say offer for sale, then explain as in this case you've been able to explain. Because if you say advertising is actually very broad. It can in this case be able to apply even to all of them. Because in all of them, you'll have to go out publicly in most of the instances, and therefore you'll be advertising. And in this case, you'll likely be using what? The prospectus. That's what you're having to say. A prospectus is a notice or advertisement issued by the company, inviting members of the public to subscribe or apply for the company's what? Shares. So we've been able to get my point, Doris. Statement in lieu of a prospectus is not the same as rights issue. No. Edward, why are you confusing? Rights issue, having to say, is a method where the company, in this case, they still issue out an advertisement, as our Doris is having to say, but in this advertisement, they are only inviting the already existing shareholders. That's what I'm having to say. In this case, it was internal marketing. You don't go out to look for any new shareholder. You already have your shareholders. You tell them, ng'ombe tunaenda kula peke yetu. So in this case, you are the only person that I'm going to give you a portion, a right to get a portion of it. That is a rights issue. That is a rights issue. So in this case, you talk about in this case, statement in lieu, you can even approach external. So it's not the same. It's not the same. Statement in lieu are representation of the prospectus. But now in this case, you target investors private. You know what it means privately? Unaenda unamnong'onezea kando. Sio tunaenda unaanza kujiannounce kwa radio ama kwa gazeti. Unaenda unamnong'onezea kando by the way. na nyama hapa. But now in this case, you're talking about what external party. You know, with the rights issue, already existing shareholders. You get the point? Yeah. Any other question? Any other question? So I've sent not up to each topic. I've sent up to topic. I've sent up to each topic. Topic 8. Is it really 8? Wait. Is it really 8? Up to topic 8. Are you sure? Yeah, I sent the others. I sent the others. Francisca says up to topic 15. Seems you people are behind. Francisca is way ahead of you guys. Francisca is way ahead. Amanda, you need to check. If Francisca is saying in this case 15, then I must have sent, but I just resend. I just resend the other topics. I just resend. I think we can end there. So for some of us who are new, we can resend. So you're going to resend and make sure you come with the notes. You print the notes and have them. Print the notes and have them, because if you wait for me to dictate for you notes here, I don't dictate notes. I don't. Those who have taught before, they know. I don't dictate notes in class. If you wait for me to dictate, you better print and have them. Be working with them like a dictionary. When I say, look at this area, look at that area, then we go like that. Because if you end up having to dictate notes here, you know, this class can last only 3 months. So in 3 months, you won't be able to cover the syllabus and be able to revise. So you're far much better off if you print the notes and be working with them like a dictionary. Everywhere you go, you can be having them. When you have a class, open them. Open them very quickly, because ideally I just discuss directly what is in my notes. I don't discuss anything outside the notes. Anything outside the notes, but of course, sometimes we use a bit different outside the notes. For example, in my notes, we don't have a term like marambas. So that's what I will just use it for maybe explaining or something. It is not there. So, but what I discuss, the other things, it is directly from the notes. So you're far much better off if you have them. If you have them, I think we can end there. So let's meet on Wednesday. Otherwise, thank you so much and have a good night.